Can you disinherit someone under your estate plan? The answer is absolutely. It is completely your choice who your beneficiaries will be. But we have some suggestions, and you may want to stick around to hear them. Before we get there, however, I'd like you to think about a close friend of yours who's struggling through a what-if scenario, but they were better prepared because you shared this video. We would appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, and hopefully together we can help some folks along the way. Now, often a proper estate plan is going to include some language where it states that if a beneficiary tries to fight the wishes of the creator of that estate plan, that they could lose their own inheritance. And that's the reason why some attorneys will suggest that you give a nominal amount, even to the children or whomever that you are planning to disinherit. I don't agree with that. And I think giving $1 or $1,000, $10,000 doesn't make a difference in their mind if others are being treated, better than them and they plan to fight against it. They're going to do it anyway. So in my mind, it is better to represent your wishes clearly in writing and express whether or not that disinheritance would continue if all of your other beneficiaries were not there to receive. For instance, just to put a little perspective on this, if you have 3 children and you're disinheriting 1, well, if those other 2 children are not around to receive the inheritance, would you then want it to go to that other 3rd child who didn't plan to give something to? Or would it go to other parties, so charities, other families, friends, whoever? You have to make that clear as well. Because there's always this what-if game, right? It's not really a game, but as you can imagine, we have to go through all the scenarios and permutations of what happens when. And this is one of those if especially children or grandchildren are being disinherited. Now, in addition, it is always my suggestion that parents or any other parties who are disinheriting those that would be considered your heirs at law. Okay, for some folks, those who don't have children, it could be your siblings, closest living relatives. But for this purpose, we're talking about a parent and a child. And if you're disinheriting your child, we have our clients write in their own handwriting a letter detailing the reason why they've made that choice. Now, this could be anywhere from we've given them a lot of money during their lifetime, they're just ungrateful and they don't speak to us, whatever the case may be. We want to have that in your own words. And this is often the strongest tool and goes a really long way if litigation is instituted later. And I say this from experience because I was once deposed in a case that I was a drafting attorney. And that document alone was the clinchpin item that allowed my prior client's plan, she was then gone, but allowed my client's wishes to stand. And so that's an important piece as well. We hope you've learned something new here today and choose to share. And as always, please take care.